have been paid, but the contractors are unable to complete them. Some codes, when you look at them, they were not supposed to be where they are. It would have been there are other deserving counties or areas where they have a lot of cases that requires some space to use. That is one area that I would want you to tell the Commission immediately when you come in, what are you putting in place? That's number one, so that you can answer all of them. Number two is about misappropriation of funds. When you go to stations, you get people that they steal the money, they use parallel receipts, they don't even bank the money, and that is it. The only thing that happens later on is for these people to go through a very long disciplinary process that eventually they'll be fired, but the damage will have been done and access to justice will have been hampered. What are you going to do about it? Number three is the issue again of human resource. You get rampant absenteeism. You get people drinks a lot, people at work, they are drunkards, they don't perform as required. There are a lot of unethical behaviors, and some even extract decisions of magistrates in a way that is not supposed to have been done. That is another area on human resource. What measures are you going to take, or what are you coming to do immediately when you enter the office to reorganize the issue of operation and management? You've talked about ICT. I don't think I'll go there. And the other number four is planning. Many a times we receive complaints, or we receive even reports from DPOP, of Directorate of Planning and Organizational Performance, and you realize that the judges and magistrates dispute their data. They say, this is not my work. I know what my output. I know what I've done in a month or in 3 months, and therefore I don't agree. To the extent now that it becomes the award against the planning. What are you going to do to streamline that so that we get harmony and we focus on real issues? Please.
Well, thank you. 3 issues about stalled projects, which you linked to perhaps project conceptualization and planning. And when I was preparing for this interview, it is clearly stated in the report that even if this money that has been allocated as the annual budget for the judiciary, the 18 billion, it is not all released together. It is released in tranches, and sometimes a checker is delayed. So if you had contracted somebody to build a court, and 6 months down the line money is not being released, then the project stalls. This is a serious conversation to hold with those offices that Commissioner Gishoyi has me, because when we have a project that is ongoing, everybody needs to own this project. It's for Kenyans. It's not really for judiciary, it is for serving Kenyans, so that that project is completed within the time that is provided. Another thing I mentioned, value for money. Is there value for money in this building? We all have built a house, so we can have an idea of what it costs to build a house, to build a court. So that's a very key area, ensuring there is a value for money. And if that is done, I don't see any project stalling, because there is no suspicion, there are no audits, that are being called upon so that you can verify and then you can move forward. So accountability here, getting value for money is important. And then misappropriation of funds is a serious management issue that as the CJ has the oversight for the entire, doesn't micromanage the CRJ, who is the accounting officer, but must work hand in hand to make sure all the loopholes where judiciary funds are are sealed. And with technology now, that is easy because judiciary is cashless. You can't transact, you can't pay for any service with cash or a check. You have to use the digital platform and make sure that those platforms are credible. They are also not sabotaged on the other end so that people are putting money, but it is not coming to the judiciary account. It is going to another account. So that requires a very, very keen oversight. And then the other problem of the human resource, people coming late. We need to enforce the code of conduct strictly. It outlaws coming to work late. It outlaws being drunk at the place of work. And, you know, putting together these leadership teams, and I think the former Chief Justice is trying to do this, put teams, leadership teams in every court. And what I would hand it to those leadership teams so that they are effective is peer review. If I'm the end of the station, I'm the resident judge, I'm the presiding judge, I consider myself the father or the mother of that station to nurture all the staff there. If somebody is having a social problem that is causing them to drink, speak to them, call them to lunch, find out what is the problem, counsel them, and watch them, and you know, support them so that they can be able to overcome whatever the challenges that they are facing. The other one is data collection, PMMU on performance. Data collection is a big problem in the judiciary. And I say this from an informed position when I, as the chair of the NCAJ special task force on children, we wanted data of the number of cases for children that are pending in our courts. It is a tall order to get data. And also when you get that data, its credibility, whether it is correct. So another culture which we need to inculcate, and I'll take this very seriously. And even when I called, because I'm a trainer for judges, for magistrates, newly recruited judges, inducting them, I always tell them, when you go to a station, the first thing you need to know is your data. And the best institution that has best data keeping is the prisons. Oui. Today, if we visit any prison, the person who will meet you on the gate will tell you, today we have so many prisoners, so many women, so many men, so many children. But when we visit the court, nobody will stand there and authoritatively tell you, today we have so many civil cases, so many criminal cases, so many, and this is their money we have collected. So that kind of accountability and ownership by the stations themselves, that I can be able to work on.
Yes, I think you've answered. I still have a problem following up from Commissioner Gishoi and Commissioner Macharia on this issue of diversity, issue of tribalism, or the so-called face of Kenya in an institution, which it looks like it's a lip service. People just talk about it, but they do nothing about it. To the extent now that even during recruitment, there is no conscious decision to right the problem, to correct the issue. No, so I don't know, what is your view on this? Because when you see Article 10, it is very clear on inclusivity, all that. And everybody, everywhere talks about it. In all institutions, whether executive, legislature, judiciary, they talk about face of Kenya. But when you really go down to look at it, nobody does anything about it. Nobody's correcting it. As you are coming in as a new Chief Justice, what is your plan to correct this problem, which is a constitutional requirement? Is there any plan that you have that will enable us correct the situation? Would you like propose that as we are advertising now, as we perhaps have gotten enough data to know how many are coming from where, do we even indicate and say people from Himalayas or Florida need not apply to balance off the numbers? What is this that you will come and do to ensure that the judiciary as a justice-giving institution will be an example to others, because that is a problem. Number two on that, so that you can answer all of it, and that will be almost my last question, is we are also concerned because you bring in a senior person like a Chief Justice like yourself. You come to the office, and within 3 months, the first thing he or she will do is to flood his or her office with people from the same village. To the extent now that even the language in that office, even business, official business is transacted in a particular, dialect. How? We need assurance that when you come in here, you will be a true Kenyan who will ensure that each and every deserving person, whether she or he is coming from the village or from the end of, from El Molo area or wherever, will get an opportunity to serve in judiciary, and more so an assurance, because we've seen most of the time you get, not only in judiciary, everywhere else, a senior person positioning, practicing what we call nepotism, positioning either his former schoolmates in strategic areas, his tribesmen or her tribesmen, or people who they go together to a particular church or they belong to a prayer group. How are we going to handle this? Because we can get very good officers who have very good ideas, everything. But this menace, this problem that has caused a serious problem in this country, always brings down those good officers and good people who can run departments and institutions in this country. Could you please highlight those ones and tell us what action are you going to take to ensure that these problems are corrected?
Yes.
Thank you.
Thank you. And this still takes us to the policy, the Jsc Policy on diversity, which I believe was informed by those problems, Commissioner, you're discussing, and it looks like it's a major problem. So probably this diversity policy is not being implemented. And I, as the Chief Justice, I will make sure that it is implemented. Staffing the office with my kinsmen or kinswomen will not happen. I'm a person who is driven by very high values of professionalism, a human rights defender, a defender of the Constitution, and which is really a calling and a requirement for my office as a judge, that I cannot favor somebody on the basis of the tribe, and I must always be directed by the values that are in the Constitution. So having come from that place I described for you and arriving at this Court of Appeal judge that I am today, I'm not about to bend my oath of office to favor somebody in any way, either in the case or in the job, to bring them to my office. I wouldn't even be able to work with them.
There is a statement you gave when you were responding to one of the commissioners, and you said when you were in Nakuru, it reached a time when you told advocates and I don't know who, the stakeholders, that I don't hire magistrates here. Can you go to Nairobi and go and sort it out? Do you think it was a fair decision?
It was the right way to deal with the problem because litigants were suffering. And I had written letters to the office of the CJ explaining that we are short of 5 magistrates. And litigants are suffering. The ones where cases were already fixed, they are coming and going. They are almost on now staging riots. So when we had a meeting with the bar and bench, we examined the problem. Where is the problem? I've written letters, no response. I've placed calls. I haven't gotten any. So I said, please go and see the registrar. I'm talking to him. I'm asking the letters I've reached. Please go see him and let him book an appointment for you to see the CJ, because the backstops are the CJ. That was the right thing to do then.
Yeah, thank you. I thought it would have been you yourself coming to camp at the CJ's office
I had done
or registrar.
I had done it, Honorable Commissioner. I had written letters, I have made calls, and I had actually come to seek an appointment.
So it's only that you answered very well when you talked about how you will push for recruitment or appointment of the 41 judges.
Yeah.
You rightly answered that you will book an appointment and insist.
Yes.
Because I had already had that fear that now we give you this position as Chief Justice.
Yes.
The executive refuses to hire 41 judges, and then you will tell everybody here, can you walk to the house on the hill and ask him to,
Yes.
to register? So I thought it would be fair to as a public officer to really take the beating on behalf of the public.
Yeah.
Go, come, sort out, and then you say, okay, I've gotten one, I've got to do yourself, so that you become the face of the Chief Justice without necessarily allowing people to come and
Yes.
look for, that is what I thought.
Yeah, luckily because of the bar bench interactions.
Yes.
Even when we had that meeting, I called the registrar and said, please give appointment to these lawyers from the Rift Valley Law Society.
Okay.
And he gave them the appointment. So they went to the registrar on an appointment.
Okay.
And then he had quickly worked with the CJ and to resolve the problem.
So it worked out. Thank you. My final question is on community service.
Yes.
I want to commend you for being very passionate in community, giving back to the community. I have seen you interact a lot. You have a hospital that you support. You have children. You have some institutions that you support. That is very commendable. What I wanted to ask is, could you explain your philosophy of this public, involvement, and how will you use the same spirit that you have now, perhaps even to mainstream it in your office as CJ, and even to bring it down even to the entire judiciary as a policy, to have that face of having empathy, trying to help in a way that they are able, whether it is CSR, or how will you bring in and you mainstream it in your office and the entire institution?
Yes, I think that will be easy to work because many judges, led by my lady, the acting Chief Justice, are all involved in the CSR work. There is no weekend you will not hear, because we are on another platform, people sharing how they went to mentor school children, how they visited home for the elderly, how they visited our children's home, how they, mobilize some CSR activity. So we are doing it individually, but what you have proposed is very important. How can we have this policy? And I know within the Kenya Women Judges Association, this is very easy to come up with, and so is KMJA. They are all very community-oriented. That is the beauty about judiciary judges and judicial officers and judiciary staff. They are all very community-oriented. So this one will be very easy to implement. What drives me is that my Christian values also, I'm supposed to look out for the vulnerable and lift them. And if that is the focus of the judiciary, let us leverage the power and authority that we have, the power of convening. Even if you are a judge in a court station, you can convene and command a lot of authority to bring together stakeholders by way of court users to work towards a problem that is there in that community. Say street children, you can be able to address that problem, deal with the street children in that town or community, or whatever activity that you identify. This is a calling actually for all of us, even under the Constitution. We are supposed to look out for the vulnerable. We are supposed to look out for the marginalized.
Thank you, Judge. The last of last, JTI. JTI is an institution that is not independent, it is not semi-autonomous, it is just like a department. What is your view? Would you want it, or would you propose a policy where it can become autonomous or semi-autonomous, that it will have its own director hired, a full-time director, so that we avoid this situation of picking a judge to go and work there, losing a lot of time on his or her core business? What is your view, and what is the tradition all over the world on this issue?
Yes, Judicial Training Institute is an institution of very high stature, a very important institution in the administration of justice, in the rule of law, in the constitutionalism, because it generates information, it trains, it help in the administration of justice. And I remember there were discussions to have even an act of parliament for the Judicial Training Institute that puts in the structures of governance, funding and all that. And I think the ideas you have proposed are very good, that we need to scale it up to an independent institution, standing on its own.
Thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Lastly, we have Honorable Evelyn Orwande to ask you the last set of questions. Commissioner.
Thank you very much, Chair. Judge, it's been a long day, but I just have a few questions. A lot of the questions that I had have already been asked and answered. I just have a few questions, maybe emanating from some stakeholders, which I may have to ask you, just so that you can give us your perspective. Now, there's a feeling with some of our people out there that the way our courts are interpreting the Constitution, it opens up doors for foreign concepts that may not necessarily sit well with our values, our morals, and our culture. Now I'm looking at the NGO case and your decision in that case. From where I sit, I could see that you are drawing a line between the state of being a gay person and actualizing whatever amounts to a criminal offense under section 162, 163, and I believe 165 of the Penal Code. In your judgment, if my memory serves me right, you say that if I stood on a hill and announced to all and sundry that I'm gay, I have not committed an offense until I actualize it by committing whatever acts are provided under those sections of the Penal Code. Also, the judgment of your colleague, Justice Waki, he made an analogy from the Bible about the adulterous woman, where Jesus told her persecutors, whoever has not sinned, cast the first stone. In my understanding, I may be wrong, but in my understanding, the judge was sort of telling us not to be hypocritical and to get off our moral high horse and confront the issues that are on the ground. So do you think in that decision, or your decision in that case, is a manifestation of those fears?
Thank you, Commissioner Rwanda, and congratulations. I think I haven't met you since you were successfully elected to this office. I'm proud of you. I was the president of KMJA, so you are also my representative. This question, I will be very shy to answer it because this case is alive. It's in the Supreme Court. But it was a case of, we did not go to the interpretation of section 162 of the Penal Code. It was merely a case, should this NGO be registered? And what I said and what was the ratio in that case in the majority decision is that you cannot discriminate a person because you are assuming they will commit an offense. And that actually explains, if I say I'm gay, I haven't committed any offense, nobody can arrest me. I can't assume as a judge that you're going, and what is gay? I don't know. You know, you have to bring evidence to convince me that you have actually contravened the Penal Code. So let's not go far because it's sub judice.
Okay, Judge, let's leave it at that. My next question, I want to give an analogy. I am the Chief Justice. I, Olwande, am the Chief Justice. And there's a Kadhi somewhere that for whatever reason, I have an axe to grind with. So a complaint has been raised about this specific Kadhi, and I see an opportunity maybe to settle scores or to punish them for whatever, to punish him for whatever issues I may have with him. So I look at the provisions under the third schedule of the JS Act concerning the delegated powers that I wield as a Chief Justice. And I decide that, in my opinion, I am satisfied that public interest demands that this Kadhi should not continue the functions of his office. So I go right ahead and interdict him. He is on half pay, and I keep it that way for 2 years. Are there any checks, aside from this Kadhi going to court to sue me? Are there any checks in the administrative structure, or even in the legal structure, to stop me in my quest, when you look at our framework? Thank you, Judge.
Thank you. I just want to assure you, Commissioner Rwande, that it is possible for you to become CJ. Indeed, you can become. Dreams are varied. You can become the CJ. I think I've encountered this kind of problem that you have stated in this analogy. Because the Jsc Act gives powers to the CJ to interdict a judicial officer in public interest. But you know, that has to be considered alongside the Fair Administration Act and the Employment Act. Because this is an employee, this is a human being, this is somebody with a family. You have to subject them to those processes. Call them, give them notice, notice to answer to the allegations, listen to them. Then if you are not satisfied that they have answered properly, and then you initiate the process that is provided for.
Judge, permit me to interject.
Yes.
Yes, that framework is there.
Yeah.
We have the Fair Administrative Actions Act and all the whatever provisions in the Constitution. But what I'm asking, in the practical aspect, is there anything to hold me to account other than this person going to court within the structure in which we handle our complaints and the disciplinary process?
Whether...
Sorry, remember I am here. What I'm driving at, is there any structure to check me in my abuse of these powers?
Oh, yes. I get you, Commissioner. The structure of checking excesses of powers of the office of the CJ, judicial review is a remedy that one can use to check excesses of power by any public officer. And I think in this case it's been used effectively. We've seen decisions being overturned.
Okay, thank you, Judge. Maybe I can move on to the next question that I have. The next question that I have concerns the issue of vetting. Vetting, judges. Maybe not necessarily by that name.
Yeah.
But historically, we have seen there have been several occasions when the judiciary has been, or the judicial officers, that I'm using that in the wider sense to include judges, have been brought up for what I'd call, for lack of a better word, cleaning. We are always cleaning the judiciary. We had the radical surgery, we had the vetting, and it seems the problem has not been cured, because right now we seem, and there are those fears, that we are hurtling very fast to yet another process that we see is cleaning our judiciary. There are fears out there that this ultimately waters down the independence of the judiciary. I would like to hear your views on that, Judge.
I'm in total agreement with you, Commissioner Orwande, that every institution should be able to clean itself up. You should not open yourselves to outsiders to come and clean you. So we need to look at ourselves and see whether we are actually addressing the complaints that come to the judiciary effectively. And we must ring-fence the independence of the judiciary. The independence of judges, the independence of our decision-making, and the independence of the institution. This institution is not there just serving us. It is going to serve generations to come. So it's important to maintain the dignity and the independence of the judiciary. This is why we must always be evaluating our processes and getting feedback of where it is not working, and dealing with those problems and dealing with them properly. If there are complaints, we must address those complaints and tell the complainants what is the outcome of the problem that they registered with the judiciary. So that we do not water, like you put it in your own words, water down the institution of the judiciary. The vetting, the radical surgeries, Kenyans are in agreement do not yield the results that are required. So we must have a system that is inside, that deals with the problem, a very strong communication department that communicates with the public the decisions that are made by the judges, that are made by Jsc when they are determining those problems. Keeping a problem for a judge who is on a Kadhi who is on half salary for 2 years waiting for a determination of their case, that's a violation of his human rights. It should be dealt with, and this is something you can agree on. When I'm CJ, we put a system, when cases come, they go for case management, and the committee sees what requires a hearing. What doesn't require a hearing, they tell the parties, and they communicate even to the complainants. What needs hearing, they fix them for hearing. And they make sure that, this is why I was talking about a very strong legal department within Jsc that makes sure that all the processes that are required under the Jsc Act, Fair Administration Act, Employment Act are followed. And it's not difficult to do that.
Thank you, Judge. I'm hoping that if you make it to Chief Justice,
yes,
should we ever come to those crossroads when we have to deal with the issue of vetting,
yeah,
you'll be a big defender.
You remember when I was the chair of KMJA, I crusaded the rights of a fair hearing and fair processes that does not interfere with the dignity of the institution.
Okay, thank you. Back to the issue of, the period when you were chair of KMJA, I've seen in your CV that you mentioned that you were involved in negotiations with the SRC for the fixing of the salaries and remuneration for judicial officers. It appears that some issues or some concerns concerning the remuneration of judicial officers were left out in the review that have necessitated KMJA to go to court. My lady, in this institution, we have an RM whose take-home salary is 90,000. Kenya shillings 90,000. And who, other than the other pressures of life, has to worry about making it from his house to work and back safely. They have no security. And I believe for a judicial officer of whatever rank, something like official transportation is not a status symbol. It has a component of security that comes with it. KMJA went to court against the SRC. There's a judgment out there. So far, nothing has been done. As Chief Justice, you're the Chief Administrator and more or less the face of the employer of the judiciary. And employee motivation and ensuring that they're well-resourced becomes part of your business. If you become Chief Justice, you'll be coming into this scenario, and we would like to hear from you what you would do about it.
Yes, thank you. This is also another live matter that we have to be very cautious about, because I think the decision of the High Court is on appeal, so I'll be very guarded in my answer, but just dealing with the principles, RMs should be remunerated properly. And maybe after I left my term, this issue should have continued negotiations. The negotiations we had with SRC were very, very difficult negotiations. Wherever place they went, we made sure we were represented, so that KMJA representative will stand up and make a case for the magistrates. So we drew a plan of how to follow up that case of the review of the magistrates' salaries. And even after the recommendations were made in the report, implementation was another problem. There is no office we didn't knock to see that implementation was done. So if this issue of RM was left and it's been determined in court and there is a judgment, that we will see to its implementation alongside other judgments that are pending. Because compliance with the court order is critical to the rule of law. It undermines the rule of law when court orders are ignored, because the next day there will be no need for people to go to court. They will resort to their own mechanism. So when I was thinking of this position, what I see as a way out is that the National Council on the Administration of Justice should have a department on the implementation of court orders, because where the court orders have not been implemented is where the government is involved. So that can happen. So that it is the concern of the AG that judgments are not honored, decrees are not satisfied, because he is concerned about the rule of law. He is concerned about the administration of justice, undermining the administration of justice. Is the concern of every ministry that is the judgment debtor, that they haven't paid the judgment debt. So can we regularly review these judgments and see why these ministries are not paying? I know a big exercise was undertaken earlier on by one of the governments, I think the NAC government, the Kibaki government, of evaluating the pending bills, seeing what is the hindrance in this. So this is something I would be able to deal with and sort out. Yes.
Let's now move to we receive information, complaints from people of all walks of life, in whatever capacity they may choose to present their complaints. So there's one that we received concerning a matter you handled, the National Cereals and Produce Board versus Erad Suppliers and General Contracts Limited. And the gist of the complaint is that you issue an order of stay of execution, or you are part of the bench that issued an order of stay of execution on the strength of a letter which you received from the Permanent Secretary in the Ministry of Agriculture, which was addressed to the Registrar of the Court of Appeal. So the complainants in this matter are raising concerns about your independence and your integrity. What would you say about that, Judge?
Yes, thank you for raising that. What I would say is there was an application for stay of execution before the court. There was a notice of motion seeking stay of execution. I was in that bench. It was the decision of Githinji, former Chief Justice Maraga, and myself in 2012. I'm surprised nobody raised that issue when Justice Maraga was on this seat being interviewed. So when the matter was called out, the presiding judge was Justice Githinji. And as he was going through his file, and mind you, the file of the presiding judge is the one that carries correspondence, he removed a letter from his file and said, also, in addition to this application, the CS has written saying that they are about to be attached for so much money. It was a lot of money. I think 380 million. A serious board was about to be attached. Please, can this case be expedited? Litigants write that every day. They write to court saying, please, can you have my matter heard? So we deliberated on the application on whether we should give an interim stay to stop the execution. And we were of a unanimous decision that we needed to stay because the facts of the matter revealed that the appeal was arguable, and unless stay is granted, serious board will be attached and they will have no way of recovering this money. This is one decision that goes to show timely intervention, judicial timely intervention, can save public resources, because subsequently it's public knowledge that Ireland and the directors were charged in a criminal case for corruption, fraudulent dealings, and production of documents which were fake, and they were actually sentenced to so many years and fined. So I don't see what we did which was wrong in that decision. It subsequently went to the Supreme Court, and the Supreme Court agreed with us.
Okay, thank you, Judge. I'll now move on to the documents that you had submitted. You submitted a wealth declaration. We required your last 3 declarations. You submitted only 2. Why is that?
That was an oversight. Actually, because I saw you ask that question to my colleague, Justice Itembwe, I went back once and I read, we were submitting many documents. That was an oversight. I have the third one and I can submit.
Okay, thank you.
Yes.
At the same time, you also did not submit one for your spouse.
Okay.
Would you be willing to submit that as well?
Absolutely. By tomorrow.
Now, I looked at the wealth declaration form you filed for December 2017. In the description of assets, you have an asset, you had 2 houses, one worth 10 million and one worth 8 million. I think one is 209/386/6, and the other one is apartment number E12. In the subsequent year, in the subsequent declaration, okay, you also had another property, that is house number 148, site and service, is it Kuzet, worth 500,000. And in your current declaration, the latest declaration, there is no indication of these 2 properties, yet there's no commensurate income, but maybe we would say you disposed of them or something like that. Maybe if you could explain that for clarity.
Perhaps this is also an oversight that I need to check. Those properties are still there. Koje is a house in Meru, it's still there. Yes. Yes, I can update.
That's all I have. Thank you.
Thank you very much, Commissioner Orade. Commissioners and the judge, you have come to the end of this interview. Yes, Commissioner Mwilu.
Thank you. I know you're tired, my lady, but you have sat there as long as we have sat here.
Yes.
Good. Now, I need to clarify one thing from this end myself, and then clarify 1 or 2 things from that end. The first one is that, of course, this interview is being watched everywhere, and it's a permanent record. And I would not want, on behalf of the institution that we serve, to remain on record the fact that we do not have small claims courts. This country has something called ease of doing business, and which is a condition we have to meet under the World Bank standards. Under that commitment, I gazetted 3 magistrates to commence a small claims business, a small claims court in the Milimani law courts only about a month and a half ago. So that we are not underrated because of my lady, your statement.
Yeah, congratulations.
And
really
I thank you. This country does have small claims courts, and we have already in Nairobi 3 magistrates undertaking that exercise, for which reason we upgraded our rating.
Great.
But for COVID, I would already have done another 2, but because of lack of movement, that has to wait until the country is reopened. At least the 5 counties are reopened, and then we are able to move and launch those. That clarification made, my lady, I am obliged to ask you this question, because as our team leader, you are the role model. When answering questions from Commissioner Majanja, you said that the matter that you had outside hours, you compared that to the midnight sittings of the Supreme Court. My lady, you and I know that we have regulations that derive from the offices we hold. And I need to mention here that first, the Supreme Court has only 14 days within which to deliver an extremely important determination. That's number 1. Number 2, for the Supreme Court to sit at midnight, as my lady said, it took the Chief Justice to authorize sitting out of and beyond hours. As is the practice, my lady will recall that when you and I were in the High Court, the Court of Appeal had occasion to make determinations and have them served to a particular sister judge of ours who was sitting up to 8, 9 o'clock in the night, and the Court of Appeal overturned those determinations because the judge sat beyond hours and without authority. So the clarification I further seek following, my lord, the commissioner's questions is this, my lady. Did you establish the bench? Did the bench establish whether or not the CJ had authorized a sitting outside hours, the importance of the matter notwithstanding? Did the bench authorize that? And since you sat on the bench and you are the one being grilled, my lady, you are the only one who can answer that question.
Yes.
The third and final issue is this. When Commissioner Gishoi, and I think also, yes, Commissioner Gishoi at least, asked, or did it begin earlier, how you will resolve the problem of the 41 unappointed judges, now 40, you said that you would pick a phone and call the appointing authority. Those are my lady's words. This is my question arising from that answer, and it is this. You and I were still serving here when our immediate outgone boss stood on these stairs and told us that he had tried to make calls, and calls were neither picked nor returned. That is in the public knowledge of the people who live in this country. Does my lady have, one, either an assurance that my lady's calls will be picked, or two, a way that will make my lady's calls be picked? Sorry, I said it was the last question. It isn't. The other one, like my brother, Commissioner Macharia, I knew you when I was still in practice from your activism, okay? Something you were very proud of during those days, and something that those of us who saw you then cannot divorce from you. You know, you hear Mother Kome, my lady, the first thing that comes to you is this. This is the girl who fought government. You so fought government, and you and I have discussed this thing several times, that there were times you were just scared whether you would be there the following day. Remember? As my lady changed, as Chief Justice, is my lady going to fight government? If the answer is yes, how is my lady going to do that? And please don't tell me, don't tell us that you would now be the CJ, because activism is activism. If my lady would not fight government, whatever fight government means, and I want us to refer to the period that is in the picture right now, and which my lady explained to us. You said during the Kanu, you said that. During the Moi, you said that era. You were running all over. We saw you, we heard you. So has anything changed? And would you do things in the same manner? If not, why not? If you, the first clarification was from our end to protect our work. The other three are for my lady to respond to. Okay. I thank you once again.
Thank you very much, Honorable Acting Chief Justice. I think you have clarified the last one when you said it was really not a fight, a physical one, because we were presenting ideas and arguments why we should have a constitution reviewed. We were presenting the values that are solidified in the constitution, the benefits for which we are deriving now. We were asking the government, please respect equality. Equality is a value here. Please respect human rights. Human rights cuts across this constitution. So what I was doing as the chair of FINDA was situational. That is the job that I had. That was the job description that FINDA gave me. As the chair of FINDA, please, we need to get law review where equality is respected, there is non-discrimination, women and children are protected, the vulnerable are protected, people are no longer arrested and charged with trumped-up charges because they are in a meeting. People are not arrested and detained without trial. That was defense of human rights. And I think I explained earlier in my presentation that whatever work God puts in my hands, I do it with passion. I remove all my arsenals to do that job and achieve what it is that I have to achieve. Now, as a judge, have I changed? Completely. I have changed. Because the job description of a judge is to decide cases that are before the judge, not to express any view that may compromise your decision-making ability, so that when people come to court, they ask me to recuse myself. I have to abide by the code of conduct of the judiciary. So my performance as a judge in the last 18 years speaks for itself. That was a former job. And I think many people have a former job and a new job. So this is the new job that I have. I am government as the CJ of the Republic of Kenya. I am part of the government. I'm heading the other arm of the government. And therefore, I will engage them in finding solutions to all the problems that we have. This is our country. It's a beautiful country, capable of delivering on all fronts, social, economic, political. So we need to pull together and deliver, and making everybody understand what is independence and what is interdependence and what is service delivery. So that I would assure you, my lady, that we will work in a very coordinated approach, always the Constitution being our north, our code of conduct, the Judicial Service Commission guiding us on what to do. To resolve the 40 cases of judges that is pending, you asked me whether I have any assurance. I have none, because I don't know anybody in the executive. The closest I came to His Excellency, the President of the Republic, is when he came here on launch of the State of the Judiciary report, and we were invited at the stairs there to take a picture. So that is the closest I've come. But I know when I'm occupying this office authorizes me to pick up a call and they ask to speak to His Excellency, the President. Even if it has been tried before and it has failed, I'm not the one who tried, so I must try it. And I have faith. I'm a woman of faith. I believe I will be able to explain why I want to speak to His Excellency to have a meeting. And I believe He will give me, because it's not for myself, it's not for my sake as Martha, it is for the sake of the Kenyans. And then the last one, my lady, you asked, was whether we've checked whether the CJ and authorized the sitting that happened beyond the hours. When we were in the High Court, we did not have the High Court Organization Act, and we did not have the Court of Appeal Organization Act, that now gives power to the President of the court to arrange the course list and empanel the judges. So the authority and my power and my supervisor is the President of the court. So if the President of the court has empaneled a bench and he has drawn a course list asking that I come and sit, it would have been insubordination on my part to say I will not come to court. I am a Kenyan, I'm a responsible citizen, I am a judge, I know my responsibilities in exercising my discretion. It is always to attain justice. At the end of the day, you ask yourself, what is the justice of the matter? And when I came to court and I read the file, I saw the justice of the matter was to avert a constitutional crisis, because the Constitution does not provide, if the repeat election does not happen, what happens? I saw the country going into darkness, and I said, if exercising my discretion to stay the order can save the country, from a constitutional crisis.
My lady, the merits of the matter are not in dispute at all.
Thank you.
We're talking about the process. To date, maybe I could also mention here, to date, it is still the Chief Justice. I haven't seen the provision in the 2012 Acts, the Court of Appeal administrative one, the High Court one, the magistracy one, where it is stated that the power was taken away from the Chief Justice to authorize a sitting either on a public holiday or beyond hours. And it is still the Chief Justice who gives that. Maybe that is one of the first assignments we work on when you arrive.
Okay.
Thank you very much, my lady. Thank you, Chair.
Thank you very much. So now we come to the end of this session. I would like to thank you, Honorable Judge Kome, for coming for this interview. Thank you for your honesty. Thank you for being very open in answering the questions that were put to you by the commissioners. And let me also add that we also thank you as a commission for the work you are doing yourself and your colleagues, judges, in terms of administration of justice for Kenyans. So we want to thank you. We also want to ask you at this point, Honorable Judge, whether you have anything to tell us, maybe something you left out and you feel that the commission needs to know.
Okay.
And after that, you can ask any question that you may have.
Thank you very much, Chair. It's been a long day, I agree. Like a good lawyer appearing to present myself and sell myself, I reflected on myself and what I would do, what strategy I would employ, what networks, what kind of leadership I would bring to the judiciary. I kept on writing notes, then I typed them, and I decided to produce a submission, which I said you'll be given a copy for record. I have spoken until I'm hoarse. Excuse me.
Maybe Frida, you can help the judge to open the
So difficult.
the bottle. Oh, okay. So, Honorable Judge, we actually had, that was brought to attention, but we felt that because we had not given that opportunity to other applicants, we didn't want to see it before. Okay. But now that you have talked,
yes,
you can submit it to us. Thank you.
Yes, I think a copy has been availed to you. It gives my strategy, what I perceive to be my role if I became to the Chief Justice. It has a rudimentary drawn strategic plan that has my vision to build a judiciary that is independent, efficient, accessible, and responsive to the aspirations of Kenyans and a true guardian of the rule of law. I put the objectives there, which I have discussed at length when I was answering questions, key objectives and deliverables, what I will do in financial management and support the independence of the judiciary, what I will do to build partnerships and enhance synergies in coordination, especially the NCAJ, which I see the collaborating body that brings all the stakeholders in the administration of justice to sharpen their skills in their service delivery, because justice is like a chain link. It is weakest at the weak point, and it is strongest at the strong point. So it has to hold together, pull together, so that we can all stand to defend the rule of law. So this is the write-up. It doesn't need, it's a submission, because I used to be a good lawyer when I practiced law.
And we assume, Judge, that a lot of those things, you have talked about them already.
They are all spoken.
But you have accepted the document. Thank you very much.
Yes.
Do you have any question for us?
Not really, but to thank you most profusely. You have treated me kindly. You have done a thorough job. I've watched the other interviews. I think this is the most patient panel that has sat so long. I've appeared before, and it was, within an hour or two you are finished. So I think you are thorough in the way you have done your job. I wish you all the best. In fact, all of you are new to me as commissioners, except my brother, Justice Wasame, who I've met before in these panels. So I wish you also Godspeed as you search for the Chief Justice of this great republic. God bless you.
God bless you too. Thank you very much, Honorable Judge. We wish you all the best too.
Je, umeomoka? Kama hujaomoka kwenye Quickbit ndio mambo yote. Hapa tuko na fridge, kodi yake ni CM. Tuko na gas cooker, kodi yake ni CK. Tuko na TV, kodi yake ni TV. Tuko na simu aina ya Samsung ni SM, ama Oppo ni Oppo. My friend, mahali popote unanitizama, eka hizo kodi zake kisha utume kwa 4032353. 4032353. Alafu utakuwa unaomoka na hizi bidhaa. Kumbuka, kwenye Quickbit ni bila bora zaidi kwa bei ya chini kwa chini.
Tonight on KBC Channel 1.
Mke wangu mimi napata contract kwa mzee Chwa kufanya stage show. Stage show? Stage show. Stage show kutengeza makabati ya kosi ya vyombo.
Kwanza na nini wewe?
Nilikuwa nakusikia kondoa fundi kidogo.
Kwa shida yako nini?
Mpangaji wenu yule? Ni mpangaji wetu? Nataka rumu ile. Basi mimi nakosea nini nini?
Bwana sielewi ya mambo jamani. Mama bunja huku. Ni mtu gani mnaletea? Fundi gani huyu? Anaingia kwangu bila adabu. Fundi huyu mnaletea hata kutoka hapa kwanza. Ndio anaonekana huku. Kutoka mnaletea hana adabu.
This weekend on KBC Channel 1.